So let me get started. Let me start by looking at the effect of Dobbs on state courts, then turn to the effect on state constitutional amendments, and close by looking at state lawmaking. To begin with state courts, they have been and they'll continue to be important decision makers regarding level of protection for abortion rights. By my count, I've counted the Supreme Courts of 14 states have issued rulings blocking restrictive abortion policies in the years since Roe. In doing so, they've drawn on a number of distinctive state constitutional provisions. Let me set them out. These state Supreme Court decisions have relied in part on privacy guarantees. So we look at our state constitutions. 11 state constitutions contain explicit mention of privacy. Now, Montana is an even more select group among those 11 because Montana is one of 5 states that have privacy guarantees that are not tethered to search and seizure or information privacy of the kind that you see in some other state constitutions. Montana has an explicit privacy provision. And these sorts of privacy provisions have figured prominently in several state court decisions protecting abortion access. So that's one source of protection, privacy provision. But then there's another source of protection. Sometimes state Supreme Courts have issued these decisions grounded in natural rights provisions of the kind that are found in a number of state constitutions, in Kansas, for instance. Basically, we have Declaration of Independence type of language in state constitutions of the kind that we don't find in the U.S. Constitution. This has occasionally been a grounding for abortion rights protective decisions. You've also seen some state courts issue protective decisions drawing on due process guarantees of state constitutions. Sometimes these due process guarantees are framed pretty similarly to the U.S. provisions. Sometimes they're framed slightly differently. Finally, some state courts have grounded these decisions in equality provisions of their state constitutions. Interesting, though, the point I want to make here, though, is that a full 23 states contain equal rights amendments explicitly prohibiting sex discrimination. These are called little ERAs sometimes. Of course, the federal ERA fails, but 23 states have adopted little ERAs. What's notable is that only one of the state court decisions blocking restrictive abortion policies is actually drawn on one of these state ERAs. That's the New Mexico Supreme Court. The other Supreme Courts that have drawn on equality guarantees in state constitutions have drawn on more general uniformity or equal treatment provisions. Well, having set out the range of state constitutional provisions that are available for state courts to issue abortion rights protective decisions, these decisions will continue in coming years. However, my next point is the structure of state judicial selection and retention processes, the way we choose and keep judges, reduces the prospects of these sorts of decisions being issued on a regular basis in a number of states. Or at least, to refine my point, these decisions are less likely to be issued by certain state courts than others. What do I mean by this? Judges in 38 states stand for election in some form on a regular basis. This renders these judges less likely, on balance, to overturn policies backed by the public than if the judges did not have to face voters regularly. Additionally, in all but 4 states, judges serve fixed but renewable terms. These terms range from 6 years to a longest of 14 years. Again, these relatively short terms lead to relatively rapid turnover on state courts, especially state courts that operate partisan elections, and at times in state courts that operate nonpartisan elections. And this results in a tighter ideological fit between state courts and the public, in a way that again reduces the likelihood of judges being positioned to invalidate laws backed by the public. And so, to pull together this point, when we consider the prospects of state courts issuing further rulings protecting abortion rights, as I say, we've already seen 14 state Supreme Courts issue these kinds of decisions since Roe. But if we consider this going further, what are the prospects? These rulings are less likely than they are in the federal courts. And they're also less likely in states where judges run in competitive elections, rather than in states where judges run in retention elections, or where judges don't face elections at all. To the extent, further point is, to the extent that state courts do issue rulings blocking restrictive abortion policies, the relatively rapid turnover in state courts composition places these rulings at risk of reversal by a reconstituted court with a different ideological leaning. I'll just give a leading and very recent example of this. In Iowa, the state Supreme Court issued a 2018 ruling recognizing abortion rights. An influx of new members over the next 4 years, though, led another decision to come to the court in 2022, and this newly constituted court reversed the 4-year-old decision. This ruling was issued a week prior to Dobbs. The first of my 3 points, therefore, to wrap up this first point, is that Dobbs will provide an opportunity for state courts to step into the breach and protect abortion rights by relying on state constitutional provisions. And state courts will have a lot of state court constitutional provisions they could draw on. But distinctive features of the way we select and retain judges at the state level render state courts less well positioned than federal courts to take advantage of these opportunities. My second point. Another consequence of shifting abortion policymaking from the federal level to the state level is increasing the role of constitutional amendments in determining the scope of protection for abortion rights. As long as the U.S. Supreme Court was the key decision maker regarding abortion, simply there was little energy devoted to amending the U.S. Constitution. Now, in the decade immediately after Roe, there was a fair amount of amendment activity at the federal level, where amendments were proposed in response to Roe. But these simply never stood a chance at going very far because of the high hurdles that the Article 5 federal amendment process places in the way of amending the U.S. Constitution. That's the situation in the U.S. Constitution. State amendment processes, much more accessible. Certainly no state makes its constitution harder to amend than the federal Constitution. In some, it's no easier to amend, but in no state is it harder to amend than the federal Constitution. And in many states, it's significantly easier. The point is that because state amendment processes are so much more accessible than at the federal level, groups that are looking to shape the level of protection for abortion rights, they direct their energy not just to litigating and filing cases in state courts, but also towards enacting amendments. Think of it as a parallel track of influence, sometimes for the purpose of expanding abortion rights, sometimes for the purpose of limiting them. Until this year, the state constitutional amendment activity was entirely directed to limiting state courts' ability to expand abortion rights. 6 amendments have been adopted in recent decades along these lines. Rhode Island was actually the first state to adopt a modest form of an amendment of this kind in 1986. Rhode Island says that one particular provision of the state constitution should not be understood as protecting abortion rights. Florida was the next state to adopt, again, a more modest form of this court-limiting amendment in a very specific case concerning parental notification laws, allowing these laws to be passed even despite the court's decision to the contrary. But then the last decade has seen far more sweeping court-limiting amendments in Tennessee, in Alabama, in West Virginia, and Alabama. Tennessee, Alabama, West Virginia, Louisiana, they've all enacted more sweeping limits on courts' ability to protect abortion rights. They simply say the state constitution does not protect abortion rights. Of course, sometimes these amendments succeed, sometimes they fail. And of course, Kansas had an amendment of that kind fail overwhelmingly earlier this summer. So far, most of the activity has been devoted to let's try to use the amendment process to limit protection for abortion rights. Beginning this year, though, the trend is turning in the other direction. Amendments are for the first time appearing on the ballot for a very different purpose that would, for the first time in a state constitution, provide explicit textual grounding for the right to abortion or reproductive freedom, is the way the phrasing is in some states. In Vermont and California, these amendments are on the ballot this year and are placed there by the legislature. In Michigan, an amendment is on the ballot. It's placed there by the citizens. So the key point, the second of my 3 points today, is that efforts to influence the level of protection for abortion rights take place at the state level, not only by lawsuits, but also by enacting constitutional amendments. in a way that just simply isn't viable at the federal level. Let me turn to my third and final point. Legislating is also much more possible at the state level than at the federal level, and for various reasons. And so therefore, shifting abortion policy at the state level increases the importance of lawmaking, yet another alternative to litigation as a way of shaping abortion rights. And again, this just simply is not done that much at the federal level. Let me make clear my point. Aside from enacting appropriations riders, the Hyde Amendment is the leading example, and aside from enacting a partial birth abortion ban, and aside from a few other statutes, Congress has really played a limited role in regulating abortion. But much of abortion policy making at the state level does take place through legislatures, and of course in some places through direct democratic devices. Well, why is congressional lawmaking in this area rather limited? Partly it's because Congress can only act pursuant to its delegated powers. Professor Williams talked about this key difference between federal power and state power. Federal Constitution, Congress has its delegated powers. And so there's at least some uncertainty about whether legislating on abortion falls within these powers. We see this in recent days after a bill passing limiting abortions within 15 weeks was introduced in the U.S. Congress. And some people push back immediately, say, I'm not sure if Congress even has the power to do this. My point here is that state legislatures possess plenary powers, and they encounter none of these concerns about whether they have the power to act in this area. But most of the reason for the difference of why state lawmaking will be more prominent in this area than it is in Congress, it's just because the parties are so evenly balanced at the federal level. We often have divided control of the federal government. And when the one party does have an advantage, it usually has a rather slight advantage. And most importantly, the majority party's advantage in the Senate usually falls well short of the support needed to overcome the Senate's 60-vote filibuster rule for advancing most legislation. And so when abortion legislation has been proposed in Congress, the fate of these bills has often been they can pass the House, but they fail to merge in the Senate. This was the case with a number of Republican-backed bills in the last decade that sought to ban abortions after 20 weeks, made it through the House, couldn't get through the Senate, couldn't get through the 60-vote rule. And Democratic bills in just the last 2 years have sought to preempt restrictive state abortion laws. They could make it through the House. Again, they can't get the 60 votes needed in the Senate. So that's been the situation at the federal level. By contrast, the state level is just so different in all of these respects. In all but 13 states, one party controls the governor's office and legislature. We'll call it unified party control. And even more importantly, that one party oftentimes has an overwhelming advantage in the legislature and more than enough support to enact abortion policies over the objections of the minority party. This was seen this year alone, I'm just focusing on the year 2022, by a passage of policies protecting abortion access in Maryland, Delaware, and Washington. And I won't list all these states, but also other policies passed in a half dozen states already this year restricting abortion access. Simply put, one party oftentimes has such an overwhelming advantage at the state level, they can act through legislation. Another reason why enacting policies is easier at the state level is because few state legislatures operate under supermajority rules of the kind that we see in the U.S. Senate. Only 4 states have broad-scale supermajority quorum requirements. That is, you have to have more than a majority to even do business. And fewer than a dozen state chambers have a filibuster-type rule that requires a supermajority to cut off debate. These supermajority rules are very infrequent at the state level. They've occasionally been used to temporarily block passage of abortion legislation. It's happened in Maryland. It's happened in Texas. It's happened in South Carolina. But these are rare cases. And even these cases where we've had filibuster type of situations, the majority party eventually got its way, sometimes passing abortion restrictive policies, sometimes passing abortion protective policies. Also, nearly half the states have direct democratic institutions. Nothing like that at the federal level, but at the state level, states with these devices, voters can pass policies that are blocked in the legislature. They can even veto policies passed by the legislature, but they turn out not to have the support of the public. Abortion rights supporters have relied on citizen-initiated statutes or referenda to expand and protect access to abortion in several states through the years, particularly Western states. Abortion rights opponents, meanwhile, they have made really frequent access to these devices. They're oftentimes putting abortion restrictive measures on the ballot. Interesting enough, though, when those measures go on the ballot, they fail at a much greater rate than the abortion rights protective measures. Really, the only policies that have gotten through from abortion rights opponents have been some parental consent policies in several Western states. Legislatures weren't a fan of this. Citizens were able to get it through. My point, to wrap up this third section of my talk and turn to make just some concluding remarks, is that in the states, legislators have, for some time now, they have been and they'll continue to be a forum for passing policies restricting and also protecting abortion access in a way that's just generally absent at the federal level, where the focus is entirely on the Supreme Court and not on Congress. Well, let me conclude. One way of summing up the effects of Dobbs, and a way of kind of putting this is, what are the effects of shifting decision-making on abortion rights from the federal to the state level? And one way to do this is consider, where do groups and officials focus their energy and their activity in seeking to shape abortion policy? When abortion rights policy is primarily determined at the federal level, as was the case for the last half century, groups and officials that are trying to shape abortion policy, they devote their energy almost entirely to influencing the U.S. Supreme Court. Very court-centered. Where do you put your focus if you want to influence abortion policy? You try to win the presidency, you try to gain control of the Senate, and it's all in preparation for any vacancies that come available in the court. And then when a vacancy comes, you mobilize support for your favorite nominees, you get them on the court, and then you get to work generating cases and filing briefs to kind of present the court with opportunities to reconsider its previous decisions. That is where the energy is devoted almost entirely when abortion policy is determined at the federal level. Very little energy spent on amending the U.S. Constitution, very little energy spent on congressional lawmaking. But, and here I'll close off, at the state level, opportunities for groups and officials to wield meaningful influence are more numerous and more varied. Certainly, state courts are an important forum for influencing abortion policy. Significant attention is definitely paid to selecting state judges and litigating cases. That's a constant. But groups and officials don't confine their efforts to influencing state courts. Amending the state constitution is a viable option for adjusting the level of protection for abortion rights. Groups also devote significant attention to lawmaking, whether through legislatures or nearly half of the states through initiative and referendum process, in ways that we just generally don't see at the federal level. My point here is not a normative point about whether this is a good or bad change. It is a point about taking note of how things change and how differently constitutional politics plays out at the state level than at the federal level. This takes place generally, but now we're seeing this in full effect on the case of abortion rights. Thank you again for the opportunity to be a part of this panel and this conference, and I look forward to the discussion.
Thank you, Professor Dinan. I failed to mention, and I should have, the complete CVs of our panelists are on the little QR card for me. So with that, I'm going to turn it over to Director Caitlin Borgmann of the Montana ACLU.
Thank you, Justice Nelson. So today I want to talk about the right to privacy, what it means, why it's in peril, and specifically the stakes in Montana and for abortion rights. So what is the right to privacy? Essentially, the right to privacy has two main strands. One is the right to have information, personal, private information about yourself, kept from government intrusion without justification. The second strand is sometimes referred to as liberty, and I'm going to give a quote from Casey that I think is a good description of this other side of the right to privacy. So Casey said that the freedom to make intimate and personal choices that are central to personal dignity and autonomy is the right to privacy. The court also said, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. In the U.S. Constitution, the right to abortion has been, and the right to privacy generally, has been held to be implied in the 14th Amendment's Due Process Clause. But the word privacy is not mentioned. However, the right to privacy, the constitutional right to privacy under the U.S. Constitution, is nearly 100 years old. As early as 1923, the Supreme Court recognized through various decisions that liberty gave, in the 14th Amendment, guaranteed a pretty broad right to privacy that include decisions such as decisions about procreation, child rearing, and marriage. In Montana, the right to privacy is explicit in the Constitution, and it is found in the Declaration of Rights and therefore is a fundamental right. So, to quote from the Montana Constitution, the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. That is the strictest test that a right under the Constitution can have. In 1999, in a decision authored by Justice Nelson, the Montana Supreme Court decided a case called Armstrong versus State, in which it held that the Montana right to privacy includes the right to an abortion. The right of privacy, as we know, is no longer guaranteed under the U.S. Constitution after the Dobbs versus Jackson Women's Health Organization decision this past June. So we know that it's been outright rejected when it comes to abortion, and based on the reasoning of the court, we have reason to be concerned about other of these privacy rights that I mentioned that are encompassed in the federal constitutional right to privacy. And the reasoning of that decision invites reflection on the role of the courts in protecting rights, as Professor Dinan was talking about, and concern for the future of rights, especially the right to privacy, including in Montana. So some basics: when the federal Constitution protects rights, it sets the floor, not the ceiling for such rights. So states can protect rights more strongly than they are protected under the federal Constitution. And the Armstrong decision did exactly that. So as I mentioned, Armstrong was decided in 1999. In 1997, the U.S. Supreme Court ruled on exactly that same law that was challenged, that same abortion restriction that was challenged in Armstrong. And the U.S. Supreme Court found it to be constitutional under the U.S. Constitution. So there you have a perfect example of the Montana Supreme Court independently interpreting Montana's privacy provision as contrasted with the U.S. Supreme Court's provision. So Armstrong has been Montana's Roe versus Wade since 1999. And what happens now? Well, for now, Armstrong stands. The Montana Supreme Court has been asked in 2 cases to decide if it's still good law. So there's a case brought by Planned Parenthood challenging 4 abortion restrictions that were passed in the 2021 legislative session. And the ACLU is a friend of the court in that case. And then the ACLU of Montana, along with the Center for Reproductive Rights, has brought another case that we won at the trial court level called Weems versus State, which challenges an abortion restriction limiting which medical providers can provide abortions. And in both cases, it is certain that the question of whether Armstrong is still good law will be raised. So in the Dobbs decision, the court says that it's the states that must decide the issue that Casey said is for the individual to decide. And I'm going to just not talk about, but flag that although the opinion is focused on states, it does not preclude Congress from voting, because the reasoning of the opinion is based on the idea that the democratic process should decide these questions. So Armstrong still stands, but it's only going to last as long as the role of the courts as protector of constitutional rights is respected in Montana. by the public that needs to fight for that to remain the case, and by the political branches. And when it comes to the latter, it is not looking very good in Montana. We had multiple bills in the last legislative session in 2021 that were directly aimed at politicizing the Montana Supreme Court. And we have a chilling ongoing case that is an ACLU of Montana and national ACLU case called Marquez versus State of Montana, in which we are defending the rights of trans people to change the gender marker on their birth certificates. So SB 280 was passed in 2021 by the Montana legislature and requires a transgender person to receive a certified copy of an order from a court indicating that their sex has been changed by surgical procedure. They then have to provide that court order to the Department of Public Health and Human Services, DPHHS, in order to change their gender marker. Before that law passed, they could simply submit an affidavit to DPHHS. The system worked fine. There were no problems until 280 was passed. Senate Bill 280 violates plaintiffs' state, Montana, constitutional rights to privacy, equal protection, and due process. The trial court issued an injunction in that case, an injunction pending resolution of the case, and that injunction was issued in April. It specifically enjoined the defendants from enforcing any aspect of SB 280 during the pendency of the action. And since then, the state has defied the Montana Supreme Court at every turn. It refused to comply. It then issued a new rule that was even harsher than the rule it originally issued to implement SB 280. There was yesterday a hearing to clarify the court's ruling, and Judge Moses said there was no question that state officials had violated his earlier order by creating the new rule. He said that his order reinstates the previous rule that allowed people to update the gender marker simply by filing an affidavit. Yesterday, Charlie Brereton, the director of DPHHS, said the agency was keeping the rule that it issued last week in place. So when I ask why is it so important not to politicize the courts, that is a perfect example. Rights protect us against governmental interference. Legislatures can and do enact rights. Professor Dinan gave examples of that, but they cannot be counted on to protect minority rights or the rights of those who lack political power. Moreover, legislatures can't even be counted on to enact the will of the people. I'll say a little bit more about that in a moment. Justice Alito's opinion in Dobbs stated that abortion is a, quote, profound moral issue on which Americans hold sharply conflicting views. He asserted that it's time to return the issues of abortion to the people's representatives, elected representatives, so that it can be resolved, and here he quoted Justice Scalia, to be resolved like most important questions in our democracy, by citizens trying to persuade one another and then voting. Justice Alito's view, which is commonly expressed by conservative justices, judges, and scholars, conjures a romanticized view of American democracy that is utterly false. It's important to dispel the idea of a democracy where everyone's opinion is heard and people get to, quote, try to persuade one another. In a recent New Yorker article in August, Louis Menand wrote that, strictly speaking, American government has never been a government by the people, and he gives countless examples of why that's the case. I'll give an example relevant to the topic here, which is that even though a majority of Americans favor abortion rights, this is not reflected in legislation in many states, 26 of whom asked the Supreme Court to overturn Roe, or federally. Secondly, I think the most in Scalia's quote is telling. Like most important questions in our democracy, some important questions, then, he seems to concede, and so does Justice Alito, should not be resolved by citizen vote. So which ones? Even if there were access to democracy for literally every person, there are certain rights that are simply too important to be left to majoritarian vote. And that is because majorities will rarely have the incentive to protect minority rights. The courts need to act as a check on the legislature to protect fundamental rights. That is the role of the courts. This was recognized in the famous opinion of West Virginia State Board of Education versus Barnett in 1943, where the court said the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy and to place them beyond the reach of majorities and officials and establish them as legal principles to be applied by the courts. It's interesting that Justice Alito asserts that the quote-unquote profound question of when personhood should be left to the democratic process. This question is a moral and religious question. Should the question of whether a God exists or whom we should marry or what religious practices are valid be left to the legislative process? Also, this idea of balls and strikes, that the court should stay out of these messy controversies, is a soundbite that has no basis in reality. It's not how the Supreme Court works. A referee calls balls and strikes. The U.S. Supreme Court is not a referee. It determines the meaning of rights, including constitutional rights. There is no way for the court to abdicate this role. Inevitably, the court is determining the fate of rights and shaping the law of rights, and that is exactly what happened in Dobbs. So the key role of courts, a key role, is to protect rights that are deemed fundamental. How should we know when a right is fundamental? Should they be subject to a test, like in Washington versus Glucksberg, a 1997 decision that's heavily relied upon by Justice Alito? A test in that case asked whether a right is deeply rooted in the nation's history and traditions and is consistent with the concept of ordered liberty. But I want to focus on this first part, deeply rooted in the nation's history and traditions. Why? Why should fundamental rights be determined based on what a bunch of white men decided hundreds of years ago? Our history was profoundly exclusionary of certain groups and based on violence, genocide, enslavement, and displacement. Why should the views of these white Christian men from over 2 centuries ago determine whether a right is fundamental? The Dobbs decision literally goes back to the 13th century, what some people would call the Dark Ages, to justify its decision. Fundamental rights are rights that are essential to self-actualization, what it means to be human, what it means to live with autonomy and dignity. This has to be allowed to change over time as humans become more enlightened. John Marshall recognized this, Justice John Marshall, saying that the Constitution is intended to endure for ages to come, including a future that we can see only dimly. So these are the fundamental rights that the ACLU protects, and that includes rights like religion, speech, voting, informational privacy, and, again, privacy and intimate decision-making, whom to marry, whether and when to have children, what medical procedures to undergo. Do not be fooled by the language in Alito's opinion, just attempting to distract from this. All of these rights to privacy are on the chopping block. Justice Thomas was explicit about this in his concurrence. So again, I will conclude by coming back to where I started. The Montana Constitution established numerous fundamental rights in the Declaration of Rights. The Montana Judicial Branch, with the Montana Supreme Court as the final word, is the branch to protect rights guaranteed in the Montana Declaration of Rights from infringement. Abortion should have remained protected under the U.S. Constitution for the reasons I stated. Now it falls more heavily than ever on the Montana Constitution and the Montana Supreme Court to protect these rights within our state. Thank you.
Thank you, Director Borgmann. I've got some questions I can ask of the panelists, but I'd rather give you all a chance. So I know this is a hot topic, a very important topic to all of us. So I'd like to open up questioning to all you out there. And please direct your questions to either Professor Dinan or Director Borgmann. Yeah, we'll get you a microphone.
Thank you.
Sandy Beach, you'll be next.
As you know, the legislature has taken this topic up and passed the bills that are currently in front of the Supreme Court. There is also a measure that was passed, I did not vote for it, of course, placed on the ballot related to abortion, the Born Alive initiative. But there was another bill that was brought forward, I think for the second or third time, which was to put on the ballot a constitutional amendment to amend not the privacy section, but the due process section, because the word person is in there, and to amend the definition of person to be from conception. So those would be two fundamental rights. I'm not an attorney, but those seem to be in conflict. So I think, Caitlin in particular, how would you see those playing out in the Montana judicial system, or Judge Nelson?
Thank you, Senator Sands. Do you mind just repeating that question, just the last part of that?
Yeah, and that bill failed only by 3 votes. So if they're successful in getting a supermajority this next time, that is the bill that I believe will go on the ballot going after the abortion issue, not a direct attack on privacy in that way. So if those are both in the Constitution, due process and privacy, are they conflicting fundamental rights? And if so, how are those going to play out in our judicial system as constitutional issues?
So I think you're asking Senator Sands if they amend both, whether this would be conflicting. I mean, I think it definitely would create a lot of confusion, and I mean, this is always part of the problem if a fetus or an embryo is deemed to be a person. So I assume that's what would happen with the due process changing of the definition of person, because we know that women are humans with constitutional rights, and so it is extremely difficult to, I can't overstate the number of different ways in which a provision like that would create confusion around what now happens to women's constitutional rights. Actually, whether or not the privacy provision is amended, I think that it sets up a direct conflict between the embryo or fetus that the woman is carrying and her own constitutional rights, and that is not just limited to abortion. I mean, we have already seen the chaos that has resulted from the Dobbs decision in terms of medical treatment that pregnant women are getting, even if they are not intending to get an abortion, whether hospitals are willing to provide treatment for miscarriages, treatments for cancer. And this doesn't even touch issues not related to medical care, such as provisions around inheritance and all kinds of other things that depend on determining who counts as a legal person.
Maybe the professor to tell me what's going on in other states relative to, I mean, you've got bills and cases going directly at the rights of the woman, and then this other strategy to go at the rights of the fetus as a separate issue. How is that playing out in other states?
So, in some of these cases, the audio is much better from the podium than from the questioners. But let me address what I think I heard, and if Justice Nelson wants to restate, that could help me. Here, let me provide this perspective. Of the state constitutional amendments that have been put on the ballot in various states, I actually discussed 2 types, and then there's a third type. I discussed some of the amendments that would restrict courts' ability to protect abortion rights. I then discussed some recent amendments that would explicitly protect abortion rights. There's a third type of amendment that I did not discuss because none of them have been successful yet. And these are amendments, personhood amendments, that they would go at, my understanding is that they would address some of what is in your question. They would actually state that personhood begins at the point of fertilization or conception. These amendments have been put on the ballot in about a half dozen states in recent decades. They have never passed in any of these states, including in some states where some proponents of these amendments thought they stood a chance of passing. So we haven't yet gotten to a point yet, I guess is one way of saying, where a court would have to decide how to weigh an amendment of that kind. And the main reason is those amendments have not gotten support of the public to this point.
Thank you. Other questions? Sir? Question down here?
We have one back here as well.
No?
You just have to speak really loudly.
We'll get to it.
Can you hear me? Okay.
It's not real well.
Okay. So my question is for Justice Nelson and Ms. Borgmann. I'm currently 4.5 months pregnant, so this is very personal to me. And no, I don't think I should have to bring the state into my hospital or my doctor's office for an opinion. But it applies to this conversation. As I was leaving the maternity clinic that I was going to for an updated visit, there was a young girl there, she was about 15, trying to get access to birth control, and her insurance denied her. I was so angry because she was doing everything right, trying to be preventative. And I could not figure out what to do as an attorney. I was like, oh my God, I was going through federal law. I was going through constitutional law in my head. I was like, I will pay for it out of pocket for her. But she got denied by her health insurance. And when I left, I was even more angry because I was sitting there thinking, no man going to the store buying condoms is being asked for his ID or for a prescription. We're denied it. And I couldn't think of what to do. And so my question is, this room is full of future attorneys, young attorneys, and attorneys that have been in the business for years. What can we do? What can the public do? I hear about the legislators that are up there and they aren't following the public's wishes. How do we take action, and where do we find this information to share with others to do a call to action as well? Because I was so lost and frustrated for this poor girl. And I know she's not the only one, and the conversation's bigger than abortion. In Louisiana, they can't even get IVF for people that are trying to get pregnant and start their families. So it's like, it's an expanded conversation beyond just abortion and women's rights. It's a right to have a family planning. When do you want it? And females need a prescription for birth control, but men don't. So for me, it's equal access as well. And so, sorry, this is really personal, and I'm overly emotional anyway as it is. But where do we find this information for this call to action to not only inform ourselves, but to inform the public and help others? Thank you.
Thank you so much for your question. Couple of things. I think one of the most important things, I know we hear this a lot, but it just can't be overstated, is involvement in the electoral processes. Getting informed about who is running for the Montana Supreme Court, getting informed about who is running for the legislature and what their positions are. There have been states, when I was at National ACLU, there was a trend of reproductive rights groups pushing for what we called contraceptive equity. This was like around the time that Viagra had come out, and so I'm dating myself, but and the insurance companies were covering Viagra and they were not covering contraception, and so we called it contraceptive equity and pushed for proactive legislation in legislatures to require that insurance companies cover contraception without discrimination. And that was very successful in states that you might predict, including California and New York. And those provisions were upheld in courts there. In Montana, there are reproductive rights groups, Planned Parenthood, ACLU, many other groups that work in coalition. But it has to be politically feasible to pass something like that in a court. I mean, in the legislature. And so, again, it just boils down to citizens being aware of who their elected representatives are, what their positions are, go to their town halls, ask them these questions aloud, force them to get on the record about these issues. The majority of Montanans are pro-choice. And it's very important for them to be aware of the positions of their elected representatives on these issues.
Thank you. This question is for Caitlin Borgmann. First, thank you for your service. Secondly, if you could comment more on where the court's authority comes from. You know, the executive has military and police to enforce its edicts. The legislature has the power of the purse. Where did the court's authority come to enforce its rights, particularly when you're saying the role of the court is to protect the marginalized citizens from the tyranny of the majority? So necessarily, they're going to come out with unpopular decisions. And particularly in light of what you mentioned about the transgender birth certificate, what happens when a court says this is what is the law and the other branches say, you know, so what?
So the basic question is, where do the courts get their authority? And it comes from public and political respect for the court's role. The courts are unique in not having a way to enforce their rulings. They don't have an army, they don't have police. And so it depends on the public respecting the role of the courts. And that sounds like a very tenuous basis for court's authority, but it has survived all of these years. It goes back to the Marbury versus Madison decision that Justice Marshall issued, where he arguably did something that is not spelled out in the Constitution, but seems obvious, that if the courts can't exist as a check on the political branches, then we can't have, the rights won't have a meaning. They won't be protected, because the whole point of rights is to be protecting the individual from government infringement. So there has to be a branch whose role that is, but it depends on the public understanding that role. As Professor Dinan spoke about, the state courts are more liable to be politicized for all of the reasons that he said. So it's really up to the public to make sure that it rejects efforts like what the legislature has been trying to do in Montana to politicize the courts, and to speak out against and have it be reflected in our elections that they do not accept what the state is doing in terms of its outright defiance of court decisions.
Well, let me take a stab at that. You know, since the founding of the Republic, we have prided ourselves as Americans on being governed by the rule of law. Simple principle, the rule of law. This administration, this Attorney General, this governor give the middle finger to the rule of law. This started back in 2021 when the Supreme Court issued an order prohibiting the legislature from grabbing emails and stuff off the server of the Supreme Court. Of course, the legislature and the governor's office and the AG started a jihad against the court system. And this Attorney General, through his office, sent a letter to the Supreme Court, basically telling the Supreme Court they could stuff their order. We don't recognize it. We're not going to comply with it. And then there's the business with the transgender matter that Director Borgmann just discussed. Once again, this administration, this Attorney General, this governor have told the court system they can stuff their order. And that's a violation of the rule of law. And I've been an attorney for 50 years, and it's the first time ever I've seen any litigant, any attorney general for God's sakes, any litigant in any court proceeding telling a court they could stuff their orders. You know, as attorneys, we all get beat up by the courts sometimes. We get decisions we don't like, orders are issued we don't like. We don't tell the court to stuff it. What we do is we ask the court to reconsider it, or we appeal it, or we take the process through the rule of law, and ultimately we may win, we may lose. But it's the rule of law that ultimately controls. And I will tell you right now, this administration is against the rule of law. And what do you do about it? I'd be writing letters to the editors till the editors won't publish them anymore. I'd be calling these people out constantly. I would be raising every sorts of hell I can raise with these people. Because I'll tell you what, if we don't nip it in the bud, if we don't beat it, I'll tell you where we're going to be in a couple of years. We're going to be in a fascist state. We're going to be in a fascist country. And that's really where this is coming from. Professor Dinan, I got on kind of a rant there. Would you like to jump in?
Let me just say one thing, not directly on point for the question, but get some issues raised by it. Getting back to Director Borgmann's comments, and that is, each state has an opportunity to structure its judicial system in its own way. And I guess the point I would focus on is states can and do structure their systems another way. Now, this is a 30,000 feet kind of point. Right now, Montana has the state court system that it does. But I'm raising a broader issue here, that is, some states choose to follow the federal model, which provides for significant insulation of their judges from public opinion. There is one court, Rhode Island, in the 50 states, that the judges serve for life. There are 3 other courts where judges basically serve until retirement age. That's an option. It's not an option that other states have done, but it's an option. There's also the option of having a governor appoint and a legislature confirm judges in the way that we do at the federal level. There's a wide range of ways this can be done. I will say 2 states, South Carolina and Virginia, the legislature, interesting enough, has sole control over selecting judges. And then, of course, there's the states that have partisan elections for judges, nonpartisan elections, and then the states that have a merit commission and then a retention election. My point here is that there's varying levels of protection that we can have for judges from, or insulation from, the immediate views of the public. And Montana has chosen one way. There are other options on the table for broad consideration. So that's the point that I will make as part of this intervention.
Professor, in your experience, have you ever known a state attorney general to tell a court they could just go stuff an order to hell with it? They're not going to comply with it?
That's something that I don't have an example of to bring to the table in terms of a comparative approach.
But you don't. Okay. Other questions? I'm sorry.
Since, again, you brought up the issue of how their states structure their courts, Montana is currently in the process of considering restructuring it. The legislature directly went after the structure of the court. How justices are appointed, that's been to the court. The court found that to be marginally, at least, constitutional. But there are a couple of other statutes that are still in front of the court. The biggest one that I found problematic, and I sit as the vice chair on judiciary, so I'm the one who deals with this, is that they want the justices to have be elected by districts so that they have constituents rather than being accountable to the Constitution solely, to be accountable to a constituency, because, as they stated, they believe that's politically correct, that you then be representing the political points of view of the public rather than the defense of the Constitution. I think that is one of the most dangerous measures we passed this session, and the court has yet to act on that particular issue. And I think the ACLU may be involved in that case as well, or Justice Nelson.
We've got time for one more question, sir, down here.
I'm Albert Borgmann. I'm Caitlin's father. I just wanted to make a comment to point out that the comfort that Christians think they get from Christian jurisprudence is mistaken. And if you go back to Thomas of Aquino, it's clear that for him, personhood is something that develops and is not an all or nothing affair that just happens at the point of conception. And when it develops, of course, we're left with the necessity of finding a law that draws a line that needs to be found in the process of the development of personhood. But it was a 19th century decision by the Vatican to make things clear at the expense of losing reality and touch with reality. So the point was made that conception, personhood begins with conception, and it's clear. But it's clearly losing touch with reality, because in reality, women don't act that way. So we should be clear that some of the comfort that Christians take from Christian jurisprudence is unfounded.
Thank you, Mr. Borgmann. Let's give a warm congratulations to our panel. Professor Dinan, I think we lost him. Oh. All right. Thank you all for